Here's the text of the Fourth Amendment. The Fourth Amendment guarantees the right of the people to be free from unreasonable searches and seizures, and that no warrants shall issue except upon probable cause, supported by oath or affirmation, and describing with particularity the place to be searched and the persons or things to be seized. Now, this is a business law class, and you'll notice that businesses are not mentioned in the Fourth Amendment at all. Before we start to talk about how the Fourth Amendment implicates business, let's talk first about how the Fourth Amendment has been interpreted generally. First thing we're going to talk about is searches. The right of the people to be free from unreasonable searches. If the search is reasonable, then it is presumptively valid. If the search is unreasonable, then it is presumptively invalid. So let's talk about our two types of searches. Remember, what do we need to invoke the protection of the Constitution? That's right, we need state action. State action. So this is pretty obvious when we're talking about the FBI or the police doing a search. But state action can also be when a person acts as what's called an instrument or agency or instrumentality of the state, meaning they cooperate with the state in some way. Confidential informant, co-worker, you name it. If a person cooperates with the state, then we have state action. It's not just the state that does the action. A person can also essentially collaborate with the state. And once they do, we've got state action. So that is called the person acts as an agent or instrumentality of the state. Okay, so let's move on to searches. For our purposes, we have two kinds of searches. One is a trespassory search, and the second is what's known as a reasonable expectation of privacy search. All right, so we're not covering searches of persons that are on the street because our focus is on business. So let's talk about a trespassory search. A trespassory search just means any physical trespass to gain information. Any physical trespass to gain information. Okay, so what does that look like? That means rifling through the papers of your business. That means looking through the computer files of your business. That means monitoring the email of your business. As soon as you have any sort of physical trespass, or, maybe the police tried to enter your business without a warrant, we'll get there. But at any rate, as soon as there is some sort of trespass to gain information, you have a Fourth Amendment search. As long as you have what? That's right, state action. Once the government trespasses to obtain information, you have a Fourth Amendment search. And then the question is it reasonable? Okay, so we have a very famous case, which I won't ask you to read, in which the government collected Mr. Jones's cell phone site data that showed his entire physical movements from one place to the other. And the Supreme Court considered that a Fourth Amendment search. Okay, so that was enough. It was a trespass, getting the cell phone records to obtain information. In another very early case, the police used phone company records because a person has actually we're getting into reasonable expectation of privacy, phone company records of a business to gain information about a person that they wish to arrest. Okay, so we've got our trespass searches. As soon as there's a trespass to gain information, we've got a search. Secondly, we have a search based on someone's or your business's reasonable expectation of privacy. Okay, the reasonable expectation of privacy we have two things going on. One, the person has a subjectively reasonable expectation of privacy, and it's one that society is objectively prepared to accept as reasonable. There's a reasonable expectation of privacy in whatever it is, and society is prepared to accept that as reasonable. Okay, so where would one have a reasonable expectation of privacy? Usually in an area that would be presumptively private. For example, your private office. You would have a reasonable expectation of privacy in your private corporate office. You don't have a reasonable expectation of privacy in areas that you hold open to the public. The case law holds that you have no reasonable expectation of privacy in what's called information voluntarily conveyed to third parties. So, in your business or generally, when anything that is open to the public, anyone can lawfully be in that area and take a look, you have no reasonable expectation of privacy. So you also have no reasonable expectation of privacy in conversations that you don't intend to be private. So conversations in public, no reasonable expectation of privacy. Okay, so let's talk quickly about a warrant. When do the police need a warrant? So we just talked about searches. Anytime we have a trespass, or anytime someone has a reasonable expectation of privacy in an area, then the police are likely going to need a warrant for that. If you don't have a reasonable expectation of privacy, say in a public area, or something's just lying around in plain view, then the police aren't going to need a warrant for that. I am greatly oversimplifying here, just so you know. But let's talk about a warrant. A search warrant. There are two types of warrants. We've got our search warrant and our arrest warrant. Let's talk about both, although for our purposes, we are mostly concerned about a search warrant. A warrant for a person's arrest is just for that person. It never expires, and it can be executed at any time. So if the police have probable cause, remember our Fourth Amendment, no warrant shall issue except upon probable cause, supported by oath or affirmation, and describing with particularity the place to be searched and the persons or things to be seized. So for an arrest warrant, the police have to have probable cause. What does that mean? Probable cause just means a fair probability. It's a little less than a 50-50 chance that someone might be engaged in criminal activity. What do the police have to do? They have to go before a magistrate, state that they have probable cause to believe that this person may be involved in criminal activity, get a warrant describing the person, and then they can execute that pretty much at any time, and it never expires. So any outstanding arrest warrant is going to be good essentially forever. Let's talk about a search warrant. There are a few more limitations on a search warrant. Okay, what's a search warrant based on? Probable cause. What's probable cause? It's a fair probability, meaning a little bit less than a 50-50 chance that, quoting the Fourth Amendment, supported by oath or affirmation, describing with particularity the place to be searched. All right, so for a search warrant, we need probable cause, a little less than a 50-50 chance that evidence of a crime might be found in the place to be searched, or the person who committed the crime might be found in the place to be searched. And we have to state with particularity. Okay, we're not going to go too much into that, but let's just say that in a personal context, the police have to state particular facts that justify that search warrant. Unlike an arrest warrant, a search warrant is only good for 14 days, and it has to be executed between 6 a.m. and 10 a.m., and I don't expect you to remember that. So our search warrant is more limited in scope, whereas our arrest warrant is rather unlimited in scope. Okay, I think that's all I want to talk about in terms of searches for right now. You're going to need an arrest warrant to get a person. You're going to need a search warrant to search a dwelling. The question then becomes, when do you need a search warrant to search a business? And that will be the topic of our next video.